Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, we hope you enjoy this legal education content, and today may be the day I earn your subscription. For today's live content, we are going to be responding to a video posted by someone else. This is from the channel ASD-Docs, D-O-C-S, ASD-DOCS, who has 57.9 thousand subscribers, so doing pretty well for himself. And he has this video that is, as you can see, is entitled, "Watch Defense Attorneys Conspire Against Their Own Client. Judge Retires After Video is Released." So we're going to watch this, and we're going to try, at least as best as I can, based on what we see, to try to determine if we think, or at least I think, the defense attorneys conspired against the client or something else might be going on. Now, I saw about the first minute of this, so I won't be completely responding to it blind, but after the first minute, yeah, and it's a 20-minute video, so there'll be a lot of us to respond to. Just as a sort of starting note, as a lawyer, I tend to want to assume the best of my profession. There are bad lawyers and even corrupt lawyers, just like there's bad/corrupt of any other profession you can name, right? But that being the case, however, I want to assume that my fellow attorneys are behaving properly. I've covered cases where they don't. I've covered ethics issues where they don't. We've covered cases where they don't, right? But the vast majority of lawyers, like pretty much the vast majority of any other profession, are professionals. You know, they have reasons for doing things that may not necessarily be corruption. And something that might appear to be corruption to a lay observer may not be corruption in fact. So I may be a little bit biased in this, in assuming the attorneys are not doing a bad. But I'll try to, with that in mind, try to give the best analysis I can anyway, and try to give an assessment as we go along for better or worse. Okay, so with that premise being put in place, let's get started with this.
What do you do when an officer lies through his teeth
Hold on.
and acts on false charges against you? What do you do when your defense attorneys try to pressure you into accepting a
I'll start over from the beginning since you missed that.
What do you do when an officer lies through his teeth and tags on false charges against you? What do you do when your defense attorneys try to pressure you into accepting a plea deal? What do you do when the judge in your case, along with the prosecutor and your own defense attorneys, conspire to have you imprisoned?
Okay. Well, first of all, an attorney is to give the best advice possible to their client, and in many situations, if not most situations, in a criminal case, that might very well be a plea deal. At least in the federal system, the conviction rate for the U.S. attorney is about 98% for the cases that go to trial. I apologize. Yeah, it's about 98% overall, and I think it's about two-thirds or 70% of the cases that go to trial. But there's a vast majority of plea deals, and often to lesser charges. So as a defense attorney, you have the very real proposition that your client is probably guilty, and you get to see the evidence and assess it for yourself. And the best advice you can offer might very well be to take a plea deal to some sort of reduced charges. Just because your defense attorney is working for you doesn't necessarily mean they are a miracle worker, particularly if the client has not been particularly smart in advance of the trial, right? If they've provided confessions and consents to search and so forth and so on. So, it's quite possible and even probable and even very likely that the client has done a bad and also made your life worse as an attorney. And the best advice you might be able to give is, yeah, you need to take a plea. You need to take it right now. And say, yeah, this is really not going to end well because I've been a defense attorney for some time and I can basically see into the future because this is not my first rodeo. So yeah, might I pressure the client to take a deal? Yes, I might, because I'm supposed to be an advocate for my client and give him the best advice I can. And the best advice I can give might be take the deal now, take it seriously, take it. It's not going to end well. Of course, it's up to the client ultimately to make that decision, but could I see myself as a defense attorney pressuring the client? Yeah. Is there anything wrong with that inherently? No. So, okay, let's press on.
About to witness is a massive case of deliberate court corruption.
Let's go and get a warrant. Mr. Sanchez is standing in the...
Joe's probably calling his attorney frantically out there.
Okay, so first question is, who is Mr. Sanchez? Is he the client? If so, you say he's calling his attorney. Isn't that you? So the way this is being framed, right, he can't be calling his attorney because you're his attorney. That's the entire premise of this. So Mr. Sanchez can't be, either one of two things is true. Mr. Sanchez is not the person on trial, or this is not his attorney, because just go out there and talk to your client. So that's a little bit weird.
He wants it executed. He's not going to come save him, I'll bet you.
Okay, so his defense attorney, which I guess is not you, since I guess that's who's talking. So I don't know what your role in this situation is. His defense attorney apparently wants the warrant, which in this case is a warrant for failure to appear, as I understand it, failure to appear to the court hearing. So, it's pretty easy to determine if that's happened or not, right? The trial is supposed to happen or whatever, and you're like, is he here? No? Okay, bench warrant, right? Bench warrant for failure to appear. So the defense wants it executed. Okay, I mean, there might be reasons for that, for a whole bunch of reasons based on prior conversations or something. So this may be a strategic reason. Maybe he wants to, I can imagine reasons. So I don't know what's going on here. And also, by the way, I'd be a little bit remiss if I didn't point out that these laughters and moments of laughter, it's a stressful environment. And I, like many other people, sometimes relieve stress by laughing. Just because we're laughing doesn't mean we think it's funny. I often laugh on the stream, and you've seen examples of this, where I laugh at horror, right? When things are really horrible, I tend to laugh. Not because it's funny, but because it's exactly that. It's a good way to relieve tension. So, yeah, the idea that there might be a little laughter in the courtroom, I don't think you can understand it necessarily to imply that they're laughing in the sense of they're laughing at the misfortune of their client, or laughing about the conspiracy. So I'm not sure you can necessarily read laughter into anything here. Sometimes laughter happens in courtrooms. It's true. Oh, the judge? The voice is the judge? Okay, that goes a long way. Okay, so... All right, so the voice is the judge. Okay, so let's back up then.
Joe's probably calling his attorney frantically out there.
That doesn't make any sense either. If it's the judge speaking, the judge presumably knows this is his attorney, because she was sitting at counsel's table a moment ago. So, I don't. That doesn't really make sense if it's coming from the judge either. Something's weird.
He wants it executed. He's not going to come save him, I'll bet you.
Yeah, well, if it's the judge is saying that, maybe she's seen it's not her first rodeo either. So maybe she thinks, maybe she knows a little bit more about what's going on and thinks that under this set of circumstances, this is how the defense attorney is likely to react for a whole bunch of reasons. Okay, all right.
So we're going to execute the warrant. But he's out there, probably waiting on his attorney or something.
That's reasonable.
What time did my attorney leave?
I don't understand. I'm going to get a little sad music here. And then we got this woman, the clerk, who's laughing about something, which, whatever. So,
An ASD Docs investigation. Hey guys, my name is Andre, and in today's video, we're going to be...
Did I play the part where they called the case at 8:45? I've been playing the entire video as it is, and I didn't hear that part. I'm only responding to this guy's video, so I don't think that was mentioned, that they called it at 8:45 for 9 o'clock. So I don't know what happened when they walked out. Oh, he's being arrested for failure to appear. Yeah, so he's being arrested. He's being taken to the holding cells, is what's happening in that situation.
Exposing a lot of different people. Some of these people are police officers, while some of these people are of other higher authority positions. Today we're going to be exposing UPD Officer Jared Cardone, Attorney Heather Chestnut, Attorney Daniel Torrance, Prosecutor Nathaniel Swift, and Judge Catherine Bernards Goodman of the West Jordan 3rd District Court in Utah. Before I go any further into this investigation, I must reiterate that these are allegations. You are presumed innocent until proven guilty in the court of law.
Damn straight, and I'm going to do my best. I'm going to do my best here to try to see if there's a plausible case to be made for the defense, or this seems like a corruption, since, I have a little bit of knowledge on these issues. I'm going to try to see if what seems more likely based on the evidence presented, right? As I always do. Always try to make the assessment based on the information I'm provided, like a good judge. So, I'll do my best to assess the information, and I also have to filter into account, as always, I have to filter into account that I've gone far enough into this video to determine this guy is not trying to be neutral, right? He's trying to make the case that there's corruption going on. So he is not pretending to be a neutral reporter. He has very clearly stated his bias up front, as I very clearly stated my bias up front. Right? So because I know he's trying to make a particular case, I'm going to make the reasonable assumption that all the evidence that is being presented by him is the best evidence he could find to support his case, and any evidence that is not supporting his case may not necessarily be included. Right? So I'm going to make that assumption. So I'm going to be a little skeptical of the evidence because I have a good faith basis to believe I'm not being presented a neutral picture, and I'm going to skew the analysis accordingly because that seems reasonable. Let's press on.
I'll be leaving timestamps for those of you that want to skip the whole backstory of this case.
That's fine. We can get some backstory.
Watch this video in its entirety so that you have complete context of the severity of what is really going on here. With all of that said, let's get started. This is Luis Sanchez. He contacted me on Facebook on July 8th, 2021, asking me for assistance in exposing defense attorneys, a district court judge, a prosecutor, a bailiff, and a court clerk. He assured me that he had tons of evidence to prove everything that he was telling me was true. As you can imagine, I was extremely skeptical. I'd never had a case where this much evidence was presented to me. This case is about corruption in every sense of the word. I want to give a quick shout out to Luis Sanchez's YouTube channel. After all of the lies and deceit and corruption that Luis has endured since 2014, he took matters into his own hands and filed a lawsuit against his own defense attorneys. He's a pro se plaintiff.
Good luck.
I know for a fact Luis has a bright future within this community, and I hope all of you go over to his YouTube channel and let him know ASD Docs sent you. With all of that said, here's a quick word from our sponsor, and then we're going to get right into the
investigation. Yeah, we'll just be skipping the sponsor thing.
That night. The remaining recordings taken at the police station were unlawfully deleted by police, and other reports were withheld from Mr. Sanchez.
Okay, not necessarily clear. The police may not be required to maintain the depending on the state, depending on the jurisdiction, right? The police may not be required to actually keep the tape of the interview. As bizarre as that might sound, that is the law in some places, right? So it wouldn't be unheard of in some places, and there might be law in different places, but it wouldn't be unheard of in some places for the police officer to make a recording, use the recording to prepare some written notes, and then trash the recording. So, whether or not you think that should be done or not, that is allowed in some places. And also, the police are not necessarily required to make the recording in the first place, which is exactly the reason why, by the way, in case you're wondering why. The police are not required in many places to make a video or audio recording of an interview, right? They don't have to in a lot of places. Sometimes they want to, but they don't have to. So the idea is if they're never required to make it in the first place, right, then they're not required to maintain that record because they weren't. So that's the idea, at least for whatever value it has. So, yeah. Pressing on.
Mr. Sanchez's constant demand for a trial and his refusal to pleading guilty allegedly angered his attorneys.
This I totally believe. I mean, not necessarily angered, but frustrated. Yeah.
On March 19th, 2018, Luis Sanchez had arrived early to court. He said he spent a few minutes waiting in his car to kill some time before entering the courthouse. Sanchez states he was outside the courtroom doors by 9 a.m. He also claims he attempted to walk inside, but that the courtroom was overcrowded. This was evident from courtroom video recordings. Sanchez says he waited outside the courtroom doors so that it would clear up a little before he attempted to find a seat.
All you had to do, by the way, was open the door and say, "Excuse me, I need to move through." I mean, you need to step in. So be like, "Excuse me, I need to move through here." I need to, yeah. So, if you have to appear, you have to appear. Being outside the courtroom is not the same thing. So on a legal level, right? We're going to analyze this like good lawyers on a legal level. Right? Being outside the courtroom does count as failure to appear. Now, the judge could do a lot of things. The judge could send the bailiff out there to go get your ass since you're right there. Or the judge, if they're feeling a little ornery that day, could say, you know what, I can see him right over there, but that's not over here. And so he has failed to appear, even though I can see him through the door. He's not here now, is he? So that's legal, right? That's legal. And if you are the defendant, you have to appear. You have to be in the courtroom. And if the courtroom is a little crowded, you need to say, "Hey, move out of my way. I need to move through." Judge, I'm here. Hello, I need to pass through, please. Something like that would be fine. Just saying.
Explains he did not go in because he had many times in the past been instructed to wait outside and not block the doors for it being a safety hazard.
Not blocking the doors, yes. You shouldn't block the doors. Yes, but yeah, no.
In 2018, I had a court hearing.
This makes no sense to me, by the way. He said he's tagged this. The person who's making this video has tagged it by saying, out of fear of retaliation, he doesn't want to show his face. But you're showing his booking photo, so like, what's the difference? Also, everyone knows who he is. So,
A pretrial court hearing, I believe. Court hearings weren't to begin until 9 a.m. I arrived in front of the courtroom doors around a few minutes before 9, for sure. And it was packed. It was overflowing with people, so I couldn't even get inside. So I waited.
Yes, you can. You can open the door. You can open the door and say, "I need to move through." Yeah. You are very much entitled, in fact, compelled to be there. So you should open the door and say, "Excuse me, I need to pass through." That's what you should do. Not just stand outside the door. Yeah.
In front of the courtroom doors, they have benches on the side because of the same reason. And I was waiting. I waited for a few minutes until I saw that it cleared up a bit, and I decided to go in. Once I went in, I didn't see my attorney, Daniel Torrance, but I saw Heather Chestnut, which was on my case as well.
Was on my case as well, which means she is also your attorney. Yeah? Okay. So you recognized her, said, "Oh, she's on my case." And depending on what this is exactly, right, it would be not unusual for a lawyer to send someone else to deal with it. It's really preliminary and go early on. It wouldn't be problematic. I'm sure at some point in the retention agreement, they signed off on this. He made it clear about these things, and he's like, well, because otherwise, how would he know that she's on his case, right? So he knows she's on his case, so she knows he's his attorney. So you're being represented. So yeah, okay.
A few minutes, I walk up to her and I ask her if Daniel Torrance is going to be absent.
Question from the chat said, so if a cop had told you wait outside, you should ignore them? It depends. Is it the cop if it's the bailiff coming in, and if it's the bailiff that tells you to wait, then fine. Yeah, if it's the bailiff that tells you to wait, then fine. If it's not, then you should say, if it's cop, well, it depends exactly what's going on, right? Because the cop who's giving you this directive may not know who you are. So let's frame it out completely, right? So let's assume this cop is just someone random, right? And he's seen the door is overflowing, or maybe even been told it's overflowing, and so he needs to stand there to prevent further overflow, right? And so if this random cop says, and maybe you don't know who the bailiff is too, so here's what you should do. Say, oh, you need to wait outside. What you should do is say, I'm the defendant and I have a requirement to appear. And the cop should then let you in, right? Or if he still says stay outside, then fine, stay outside, because you received direction even though now he knows. So yeah, you should make that apparent to a police officer who may not necessarily know who you are. So yeah, that's how you should handle that situation. I have a requirement to appear. I don't want to be in contempt, so please let me through. The order says appear. And the cop says you can't come in. It's like, I have to. And the cop still says no, then you have an outstanding affirmative defense.
As he had been absent at the previous court hearing, she tells me that my case had already been called and to just wait until the judge calls my case again.
Okay, let me go back and rehear that because I kind of blew over it and I want to make sure I hear this right.
Absent as he had been absent at the previous
Wait,
court
a little bit
hearing.
further back.
Other chestnut, which was on my case as well. After a few minutes, I walk up to her and I ask her if Daniel Torrance is going to be absent as he had been absent at the previous court hearing. She tells me that.
So he's aware that his attorney may not necessarily be there. He's seen that before, which again would not be atypical depending on what kind of proceedings we're in. If we're on a fairly preliminary stage, then, a random associate can do it, and we'll also save you money, which is nice too, right?
My case had already been called and to just wait until the judge calls my case again. At that moment, I realized that something was up because I had been in front of the courtroom by 9 and I didn't see Daniel Torrance leave. So
he might not have been there, but you knew he might not have been there because you've seen that happen before, right? You've seen that happen before where he didn't come to a previous hearing. It was an associate. And you recognize this woman as being someone on your case. So, okay. And if you have a problem with that, if you really want him to appear, right? If you have a problem with that, you should make that clear to your attorney. Well, I'm sure we'll be happy to appear and charge you significantly more money. But, in a preliminary stage, it's like, okay, if it's something basic, then, some random associate can take care of it. We're not probably in the throes of trials. So she says, okay, the court already called your case. So wait, what that you should do then is, okay, now you've got advice from your counsel. You should find a seat in the gallery. And if there's not one, you should stand up. And if they say you have to sit down, say I'm here for my case and it's been called or something. But yeah, you shouldn't just then go out in the hall. That's not going to fly, right? You have to be in there. If your case is already called,
I started to get really nervous. So I made sure to document what time I spoke with Heather Chestnut just in case later on I needed that information. And Gregor Novak says he was a bit late, but he was afforded no leeway by any of the officers of the court who are there all the time and know the rules and consequences of not meeting them. Okay, well, if he was late, right? If he was late, when it says be there by 9 o'clock, they're not kidding. And you probably should be in the courtroom like 15 minutes early.
It's one of those things where early is on time is late. Yeah. You don't want to mess that one up. So if he's late, the judge can do anything they want pretty much. It's like, well, you were supposed to be here by 9. It's 9:01. And now it's up to the judge to feel like, how do they feel that day? How do they feel that day? I'm citing you for failure to appear. Take him back. Okay, it's 1 minute late. I'll look past it. Be better next time. I remember a saying that one of my professors in law school said. He ran the law school's clinic. So this is for practicing law, and they help the indigent and stuff like that. And so they take cases like that, and it's inside the law school, and law students can take cases under certain limited circumstances. So you can be a law student and still practice if you wanted to within these limited confines. Anyway, so he ran that clinic, and he said to me once that he was on time, and the judge said, "You're late," and he said, "Sorry, Your Honor." Right? Because the judge is in control of their courtrooms. Like, he said he was early. The judge says you're late. Guess what? You're late. Be earlier next time, right? So yeah, this is not, yeah. So it depends how merciful the judge is feeling that day. Also, it depends on their prior interactions with you. So depending on how well this judge knows this particular person, they may not be inclined to give you any mercy that day. So, do better.
To my surprise, they had called my case 15 minutes before any court proceeding was to start. They called my case around 8:45, and...
How do you know that if you weren't there? Yeah, I don't understand.
They did it in order to get a warrant out for my arrest for failure to appear.
I do love this, like, sinister music and everything.
8:40 a.m. Heather Chestnut.
Now, he might just be laughing to himself about, like, what he thinks the prosecutor might do, right? He might not be saying, this is what I want. He might just be saying, laughing because it's like that's what he expects the judge/prosecutor to do. So, all right, let's press on.
Points at the clock on the wall. Note that court hearings and her client, Mr. Sanchez, are not scheduled to start until 9 a.m.
Okay.
Is it time? Like 8:45. 4 minutes. What's he want to do? 8:45. With Travis case? Let's call him before you get involved in talk.
Okay, then if it's 8:45 and his case is about to be called, then the relevant question would be, what did his order say? And if his order said 9, then the judge made a mistake. Also, his attorneys should know when his case is expected to be called. So if they're screwing that up, that's not great. So, yeah.
Well, I'm going to move down.
Good morning.
You thought court don't start till 9? Court starts when court wants it to start, man. I don't think there's any universal rule. If court wants to start at 8:45, I'm pretty sure they can start at 8:45.
Your Honor. Oh, you're ready? Good.
8:45 a.m. Right on cue. Prosecutor Nathaniel Swift walks up to go on record and falsely accuse Mr. Sanchez of frequently missed court hearings and tardiness.
Jerry says, judge make a mistake, that's laughable. Well, judges are human too. Judges sometimes make mistakes. This is one of the reasons we have appellate courts, for example. But yeah, it's possible. It's possible. So maybe, I don't know. If it's on the calendar, I don't know. But maybe it's not necessarily the judge who made a mistake. Maybe it was someone who sent out the the order to appear at 9. But yeah, it's, people can be human. It does happen.
Thank you. That's all I'm ready on for now.
Thanks.
Sanchez.
And Your Honor, Mr. Torrance is here today. We're ready on Mr. Sanchez.
Okay.
82, State of Utah versus Sanchez. Excuse me.
He's not present, Your Honor.
And you don't expect him? Or?
Judge Katie Bernards Goodman just asked that very important question because it's only 8:45 a.m. and she's very aware that court proceedings do not start until 9 a.m.
Is she, though? Is she? Are you sure? How do you know that? Are you going to tell me? Let's press on.
I'm sorry?
And you're not expecting him to come?
Well, I always expect him, although last time he was not here, and it was only after my secretary called him that he remembered to come, so.
Court records indicate Mr. Sanchez was present with Heather Chestnut on previous court hearings, which was ironically rescheduled by Judge Bernard Goodman due to Mr. Torrance being absent, not Sanchez.
That doesn't make any sense. If she's able to appear on the case and he has counsel present, then okay.
Mr. Sanchez has a history of coming in very late.
Out of dozens of court hearings, court records show Mr. Sanchez had been late once and missed just one court date. Note, this case has been active for more than 5 years due to the ineffective assistance from defense attorneys Heather Chestnut and Daniel Torrance.
If he thinks his defense attorneys are being incompetent because it's been going on this long, he can always hire new attorneys. So just saying. I don't know if they are or not. I don't know what's been going on for 5 years. I don't know the history of the thing, but if it shouldn't be going on this long, he should be able to determine if they're incompetent or not. If he feels like they're pressuring him into deals and he doesn't want to, he can fire his attorneys. Get different attorneys. I mean, unless they're publicly appointed, and then I guess you could go to whether or not there's malpractice, but yeah.
He has missed a few altogether.
So bench warrant?
After prosecutor Nathaniel Swift lied to the court, he then proceeds to ask for a warrant against Mr. Sanchez. All the while, court proceedings are not to start for another 15 minutes.
I'd ask for a warrant, and what we have the problem for is I don't intend on setting this. I don't want to set it for trial until we square away the discovery type issues and stuff, and so he needs to be here for that.
All right,
Okay.
we'll set a bench warrant, $15,000 cash, commenced bond forfeiture.
Thank you, Your Honor. That's all I have this morning. If I could be excused.
We're going to take him into custody. Hey, Steve.
Okay. I mean, that would be the logical thing to do because a warrant has been issued.
At 9:05 a.m., there's an overcrowded courtroom. People are standing between the courtroom doors and waiting outside for seats to become available.
You can fire public defenders in so much as you can hire private counsel. Yeah, you can fire public defenders in so much as you can hire private counsel. Otherwise, you cannot fire public defenders. You're entitled to a lawyer, not a particular lawyer. So if it's court appointed, the court will appoint someone who's able to practice law and presumably competent. And if you want someone different, you can pay for it. Otherwise, no.
At 9:07 a.m., Mr. Sanchez walks in wearing a white collared shirt and gray.
Which is well past 9:07. Which is well past 9 o'clock. Okay. So here's the problem. Here's the problem. Here's the problem. If you came to me on this with an appeal, if you came to me as an appellate judge, I would have to rule the judge's mistake is harmless error. I'd have to rule it's harmless error. Because if you had been there before 9 o'clock, right? If you'd been there before 9 o'clock and they arrested you, right? You had until 9. So that would be a mistake. If, however, You don't come until after 9. Well, you had to be there by 9. So even if the warrant was issued improperly, it could have been issued properly at 9. So it's harmless error. So there's nothing for me to do on appeal. So the judge might have made a mistake. It's just as harmless error, because if the judge had done it right, you still would have been in the exact same position. That's what harmless error means, right? The judge made a mistake. Doesn't matter. And the reason it doesn't matter is because if the judge had done it right, it still would have yielded the exact same result. So it doesn't matter. It doesn't matter. That's what the problem is. So, yeah, there's that. Let's press on.
Pants. Bailiff Steve Adams appears to inform Judge Bernard Goodman of his arrival.
He's 7 minutes late, man. He is, in fact, 7 minutes late.
Oh, State of Utah versus Bradford.
Judge deliberately ignores him in order for the unlawful arrest scheme to work. No. The judge is not required in any sense to pay attention to him. If the judge had done everything right, the order would have been issued at the right time. He was failed to appear, and she doesn't have to acknowledge him at this point. The bench warrant has been issued, so, yeah. Okay.
At 9:17 a.m., Mr. Sanchez approaches Heather Chestnut. She would inform Sanchez that a warrant had been issued for his arrest and instructed him to wait until the judge called his case again.
Fair enough. You should wait in the galley then.
Prosecutor Nathaniel Swift sees Mr. Sanchez speaking to Miss Chestnut at 9:17 a.m.
The bailiff wouldn't let him in because of corona restrictions. I find that difficult to believe. Maybe they'll get into that, but I'm not seeing a lot of corona restrictions here. I'm not seeing anyone wear a mask. I'm not seeing anyone in anything even approaching social distancing. The room seems pretty full. I'm not seeing a coronavirus issue here. So, yeah. Okay, so he's taking a seat in the gallery, which is perfectly fine. Yeah, this is 2018. Yeah, exactly. Yeah, I mean, there's no coronavirus issue. I mean, you can tell it just by looking at it.
It's now 10:43 a.m. It takes prosecutor Nathaniel Swift about an hour and a half before he finally decides to inform Judge Bernard Goodman that Mr. Sanchez is waiting between the doors. Now, mind you, Mr. Sanchez has been seen in clear view of the judge, the clerks, the bailiff, his attorneys, and the prosecutor for, again, the past hour and 36 minutes.
Well, I'm guessing that during the past hour and 36 minutes, if I had to hazard a guess, other cases have been being called, right? And they've had to deal with that for the last hour 36. I'm assuming at this point there is some sort of natural break. So the prosecutor is like, okay, by the way, this person's now back, so we could address that now, right? The prosecutor, here's what's going to happen, right? The prosecutor and the lawyers are going to proceed with the docket. The judge is not going to interrupt the docket. That's not how that works. They can, but they certainly don't have to. The prosecutor, I guess, could have said something, but he certainly doesn't have to. It's like, well, they're just following the docket and the schedule. It's like, okay, I mean, fair enough.
Mr. Sanchez can now be seen on his phone, unsuccessfully attempting to reach his defense attorney, Daniel Torrance.
Uh-huh.
Mr. Sanchez is standing in the
Was that one we'd already called?
Yeah.
And issued a warrant because he's always late or not showing up? And we're going to execute the warrant.
Okay. Fine.
So we'll see if he comes in here, calls his case.
Why not just go out and arrest him right now? I don't know, but because you can see him, but all right.
Joe's probably calling his attorney practically out there.
Reasonable guess.
He wants it executed. He's not going to come save him, I'll bet you.
Cindy says he was called and warrant issued at 8:45 before the docket time of 9 a.m. Yes, that appears to be the case, Cindy, but as I mentioned earlier, if you came to me on this with an appeal, as an appellate judge, I'd be forced to rule that that's harmless error. The reason it's harmless error is because it doesn't matter. The reason it doesn't matter is because if the judge had done everything properly, right? You're saying the judge screwed up by issuing the warrant at 8:45. Fine. Here's why it doesn't matter. If the judge had done everything properly and issued the warrant at 9 o'clock, as she was entitled to do, you still were late, right? So it didn't matter. He didn't step into the courtroom until 9:07. So if he had been there before 9 o'clock and arrested on that warrant, that would be different. But it wasn't. He came after 9 o'clock. So legally, as an appellate judge, I look at that and say, yeah, harmless error. If the judge had done everything right, it still would have come out the same way. There's nothing for me to do here. Sorry.
So we're going to execute the warrant. But he's out there, probably waiting on his attorney or something. He's good at what he does. He doesn't ask until he's between him and the door.
Yeah, DSS says it's in direct violation of what the prior judge said. He said to be there by 9, not 8:30. Yes, we all understand this, DSS. We get it. We get it. We haven't actually established that, by the way, up to this point in the video. We haven't actually established when his case was supposed to be called. So, we haven't heard anything from the court or, about like when it was supposed to happen. We know when it did happen. We've heard nothing from anyone about what it was supposed to happen. So we're all assuming 9 o'clock, but, I haven't been presented with firm evidence of that. But even if it was 9 o'clock, legally, it just doesn't matter because he arrived at 9:07. So he was late. So if the judge had issued the warrant at 9 instead of at 8:45, it would have come out exactly the same way. So it's harmless error, or at least that's how I would see it on appeal. Unless there's something specific in Utah law that would say something different. So maybe there's something in the Utah law that would somehow counsel a different result. But in the absence of that, I'm like, well, the judge made it bad, but if she did a good, it would have come out exactly the same. So what does it matter? So, yeah.
At 10:47 a.m., the blatant attempt to cover up their tracks begins. They allegedly falsify court records and justify the unlawful arrest.
If that's true, that would be a crime.
Sometime after 9 o'clock. But this isn't a social event.
Maybe that's when he saw him. Probably true, actually. The prosecutor probably had his eyes on other things.
Call it so that we can document what time he came in. Yeah. State of Utah versus Sanchez.
We know for a fact he was there at 9:07 now, so yeah. It doesn't matter.
Judge Katie Bernards Goodman and prosecutor Nathaniel Swift go on record to deliberately lie about the time Mr. Sanchez arrived at court.
Okay, Mr. Sanchez, I just want to make sure we see you before you go back. Your case was already called this morning. We just saw you arrive about 10 minutes ago, which would have been a 11:15.
And maybe that's when the judge did see him. The judge, I don't know for sure. I mean, the room was busier at the time, and the judge might have been looking at other things. She was, at 9:10, not looking for him. So is it possible? And then he says, I've been here since 9:08. So he admits to the violation. So even if we take him at his word, he's still in violation. Because 9:08 is after 9 o'clock now, isn't it?
I've been here since 9:08.
Well, you did not come to our courtroom until 11:15. This is the third time you have either missed or been hours late. So we issued a bench warrant for you hours ago. We're going to execute on it this time. I believe we told you last time if you were late, you're going to go into custody.
Yeah, okay, so if they gave a specific notice at a prior hearing, like they already gave him his one warning, right? If they already gave him a warning before on the record, not that they have to give the warning, incidentally, they could have arrested him at the first instance, but the judge was like, okay, I take a note you're late. If you do it again, I'm going to arrest you. Now the judge may have been wrong at the time she issued the warrant. She may be wrong about what time he entered the courtroom, but now that we know the facts, the judge's mistakes are irrelevant. If the judge had known the correct facts and had done things properly, it still would have come out the same way. So it's immaterial. It's harmless error. I mean, that's the way I see it in the absence of some sort of law to the contrary. So the judge is making a mistake. Maybe the prosecutor's making a mistake. His attorney is not saying anything like, oh, he was actually here at 9:08. And also, by the way, that's not even a malpractice violation. Because one of the things you have to show for a malpractice violation is, again, it would have mattered, right? So it's not malpractice if the lawyer had done everything properly and it still would have come out the same, right? Now, the lawyer should have done this, but the fact, it's not even malpractice legally. Because if the judge had done everything properly, and if the lawyer had done everything properly, and if the judge had seen him at the right time, prosecutors seen him at the right time, blah, 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 it's all immaterial in the end. Even assuming he had an order to appear at actually 9 o'clock, he was there at 9:07, kind of the end of the analysis on that one. 9:07 is, in fact, after 9 o'clock. Yeah.
So I spoke with Heather.
And by the way, Michelle says, no, it's his own attorney that wanted the warrant executed. That's bullshit. It's unclear to my mind. That is what the lawyer wanted. We did hear the quote from his lawyer saying, well, maybe we'll call it and get the warrant, right? But it's unclear to me in context that the lawyer was expressing something that he wanted to happen, as opposed to like saying what the judge would do or what the prosecutor would do, right? Well, maybe we'll call it and right, and they'll get the warrant executed. Because that seems like the lawyer kind of knows what the end game here is, right? Or should know the end game. So it's like, well, my client's not here, so maybe we'll get it executed and we'll arrest him. It's not necessarily clear he's speaking for himself as to what he wants, as opposed to speculating as to what the judge or prosecutor would want. At least to my mind, it's not clear. And it's not clear when he's laughing, when she's laughing about it, she's laughing about it because, ha ha ha, I'm engaged in a conspiracy. It's more like kind of a laughter of like, well, we're fucked. We're fucked. What else do you want? We're fucked, so why not laugh? And, I've laughed at horror shows because they're horror shows and everything else. So it's like, that seems more like likely to what's going on to my mind, at least. So that's how I parsed it.
17. I was here earlier.
Judge Katie Bernards Goodman.
Oh, Quan, we have a rule against insulting me. It is one of the rules about the channel. One of the fundamental rules of the channel is be nice. Oh, no. You don't have to agree with me. But, we do have a rule of being nice. So, you get timed out.
ignores Mr. Sanchez's statement.
Why did the judge retire? I don't know. Maybe we'll see how it goes. We'll press on.
His defense attorney, Heather J. Chestnut, remains.
Yeah, you're allowed to have your own opinion. We're presenting all the evidence, right? And I'm telling you how I see it, which may or may not be how you see it. But that, I'm entitled to opinion, so are you. And I'm trying to give perspective of what I think. And I mentioned up at the top that, I do assume the best of my profession, which, is a reasonable assumption because most of the time the profession's pretty, honorable. This may not be one of those times, but, yeah.
Silent.
Your Honor, I saw the defendant here. When I first saw him, I recognized him. I looked at the clock. It was 9:38 is when I saw him here.
So that may be true. Maybe that's when the prosecutor first saw him.
And we've had this conversation at least 3 times.
Could I just know what time the warrant was issued? What time did
Jaguar Assassin says all courts are commercial banks, period. Jaguar Assassin, we just do not have the time to deal with your soft-sit nonsense.
my attorney leave?
That, you can ask your attorney about that, but we didn't issue it until after 9, and you're here way after that.
Okay, so the judge is either making a mistake, or, I don't know. I'm not going to assume the judge is lying. It was 8:45. The judge probably didn't take a note of the time. She didn't write it down. So she might just be misremembering, right? It's not necessarily a lie. Maybe she's lying, but maybe not. I'm going to presume not because, I'm going to assume the best of my profession. And even if the judge had issued it after 9, it wouldn't matter. Anyway, $10 from Sika Dargan. Sika Dargan. Thank you very much. If they called the case at 8 a.m., would you argue the same? Yes. Yes, I absolutely would. Yes, I absolutely would. It would be the same if they called the case at 8 a.m., 7 a.m., 6 a.m., 5 a.m., right? It doesn't matter. It doesn't matter. Let's assume that he had an order to appear at 9. We haven't actually formally established that, incidentally, from any of the record that we know that for sure up to this point in the video, but let's go with the premise that he had an order to appear at 9. Let's assume that the court somehow calls it at 5 a.m. This is a very early court. It's confused because it's so early in the morning. Calls the case at 5. It says, well, he's late, so bench warrant. Right? It still wouldn't matter legally. The reason it wouldn't matter legally is because it's harmless error. The reason it's harmless error is because if the judge did everything right, if the judge had done everything right, she would have issued the order at 9. He was late. He was there after 9, so it doesn't matter. It doesn't matter. It's harmless error. If the prosecutor had noted the correct time the defendant came in, it wouldn't matter. If the defense attorney had spoken up and noted the correct time, it wouldn't matter. None of it matters. Because if all those things were different, the result would be exactly the same. In the best case scenario, the judge doesn't issue the order till 9 o'clock, right? The defense lawyer sees him come in at 9:07. The prosecutor seems to come in at 9:07. The judge sees him come in at 9:07. The defense lawyer argues my client was here at 9:07. It just doesn't matter. It doesn't matter. It's all immaterial. Knowingly filing a false warrant is a crime. Yes, if she knew that she was doing it, sure. But she could just be mistaken. Judges make mistakes too. Maybe she made a mistake. Maybe, I don't know what's going through her head, and neither do you. I'm not sure, actually, technically speaking, it could be a crime because I think this probably falls into absolute immunity territory. But anyways, either way, even if it is a crime, if she, even if she knew, yeah, this is one of those wonderful things too. Like, okay, let's go with that premise. Let's go with the premise that issuing a false warrant is a crime. Let's go with the premise that the judge doing so is a crime. Let's go with the premise that she did it knowingly and therefore is committing a crime. Okay, she's guilty of something, maybe. Does the fact that she's guilty of something change the analysis? No, it doesn't change the analysis. As to him, it doesn't. Yeah, the judge falsely filed a false warrant early, but if she didn't do that, if she had issued it at the proper time and all the rest of it, it still would have came out the same way. So maybe the judge goes to jail. It just doesn't matter for you. It's still harmless error as to you, even if it's illegal for her. Because if the judge hadn't committed a crime and done everything by the book, it still would have come out the same way. So the judge being guilty doesn't mean that you're innocent. DSS, it says it's the first case I've ever disagreed with in you, and I'm amazed. DSS, that's fine. DSS, that's fine. I mean, it had to happen eventually, right? It had to happen eventually. I've tried to provide you the legal analysis. I've tried to provide you the standards of review, right? The standard of review would be, because it's a mistake, right? So the mistake would be harmless error. So, okay, we're looking for a harmful error. What error occurred that caused a prejudice to him, right? How was he prejudiced by any of these mistakes? And the answer is he's not, because if everything was done properly, it would have come out the exactly same way. So that's my best legal analysis. You're not required to agree with it, but hopefully I've explained it in detail about why I would rule that way. If you came to me with this case, it'd be like, regardless of what the judge's liability is, if any, you wouldn't come out any differently for you. So, what do you want me to do about it? Really. How is a warrant harmless? Okay, I'll explain it again, because people, as long as people keep asking the question, I'll keep answering the question. All right? The reason it's harmless is because we're looking for something that if the judge had done it properly, would yield a different result, right? So we're looking for some error by the judge, some mistake by the judge, that if it hadn't occurred, would have changed the result, right? That's what it means to be a harmless error. So a harmless error is one where a mistake happened, but if it had not happened, it wouldn't matter, so it's harmless, right? So let's assume that his court case was called at 9, to be called at 9. Let's assume his court case was to be called at 9. The judge actually issued it at 8:45. If the judge hadn't made that mistake, his case would have been called at 9, right? His case would have been called at 9. He wouldn't have been there. The judge would have issued the warrant at 9. Right? So it's a harmless error to be issued at 8:45 because you weren't there until after 9. Because we know when the judge called the case, you weren't there, they issued the warrant. So if the judge had called it at 9 o'clock, you still wouldn't have been there. They still would have issued the warrant. You still would be in violation. They still would have arrested you. That's why it doesn't matter. If the judge had done everything legally, it doesn't change the result. So that's why it doesn't matter.
When I created the video, I tried to get some media attention to it. I contacted many local news stations, many local reporters and journalists. Nobody wanted to cover the case. Everybody refused, and the only thing that did happen was that one of the news stations or reporters that I contacted, they got in contact with the judge and showed them the video that I had posted on YouTube, and based on that, the judge removed herself from.
That's perfectly fine. That's perfectly fine. Right? That's a very reasonable thing for the judge to do, and probably a good best practices, right? The judge should avoid impropriety and the appearance of impropriety. And the judge made a mistake. She made a mistake. Now, that mistake didn't matter as to him, so it's not going to help him. But she recused herself. It's a very proper thing to do. It's like, oh, I made a mistake here. I'm going to recuse myself to avoid the appearance of impropriety. Good on the judge. Good on the judge to recuse herself. I applaud it. There's nothing wrong with it. Still doesn't change the analysis. So harmless errors is a subjective standard based on result. Well, I don't know if it's subjective. It's objective, I guess. I guess harmless error is an objective analysis, because in the harmless error analysis, we assume the opposite, right? So we're not asking subjectively. We're asking more objectively. We know the moment the case was called, he wasn't there. The judge issued the warrant for him not being there at 8:45, but if it happened at 9, there's no reason to think she would have done anything differently. I mean, she's going to do it at 8:45. Why wouldn't she do it at 9? She calls the case at 8:45. He's not there. Issues the warrant. On what possible basis would we think, oh, if she had called it at 9, she wouldn't have issued that warrant? Right? I mean, it's just, yeah, I don't think it's subjective. It's just like, yeah, I mean, that seems to be what would have occurred. So, okay. I mean, you're there. Never mind, this case has been dragged on for 4 years. Azeroth, I am not here to defend the case being dragged on 4 years or 5 years or whatever it is at this point. I don't know if that's proper or not. I have no idea. No idea if it's proper for this case to be dragged on this long or not. No idea if his attorneys are incompetent. No idea what's going on. I'm just trying to assess this one thing right now, because that's all I'm trying to assess, right? So I'm trying to assess whether this particular thing that I'm being shown right now is proper or not. Give me some evidence. Give me some evidence as to the 4 or 5 year thing. I'll analyze that too. But I can only assess, like a good judge, I can only assess the evidence that's before me. His lawyers were the one who started the case. Look at the start. It still doesn't matter. So, because if his attorneys hadn't done that, his case would have been called and they still would have issued the warrant. So it's not malpractice, because it still would have come out the same way no matter what his lawyers did. Right? If his lawyers hadn't done that, and if the judge had made, it doesn't make any difference. It just doesn't make any difference. Okay. Find me something that happened that, had it not happened, would have changed the result. All right? His lawyers don't call the case. The judge calls the case at 9. What's she going to do? Well, we have a pretty damn good idea what she's going to do, because she did it 15 minutes earlier. So there's no reason to think she would have done it 15 minutes later or not. Let's assume that, let's assume that the defense attorney had spoken up and said, oh, I saw my client here at 9:07. Let's say the prosecutor had noticed him at 9:07. Said, yeah, he was here at 9:07. Let's assume the judge noticed him and said, yeah, you were here at 9:07. Find me a fact, anything at all. Find me a thing that, if it were different, the result would be different. So far, every single mistake anyone has pointed out would not change the result. And it's hard to believe that there would be a change in the result, because assuming that he was supposed to be there at 9, which is the premise we're going with, assuming he was supposed to be there at 9, he was in fact there at 9:07, and how can anything else really matter in the end? He was late in reality. So I'm not sure what fact you can possibly point me to that will make any difference. It just all doesn't matter. Defense could have asked for a continuance. They don't just give continuances for the hell of it, and it's and they have no cause to ask for a continuance, and the judge would have probably denied it. There's no legal cause for it. I mean, the judge, I guess, suppose could have, but there's no legal cause. There's no,
From the case, I didn't get.
He was there prior to 9 o'clock. No, he wasn't. He didn't enter the courtroom till 9:07. And he actually said 9:08. By the way, he admitted to it on tape, but it was 9:07. He was not in the courtroom at 9 o'clock. No.
Attention from it, but
I think you should rewatch the video. I rewatched the video. I've rewatched the video. I understand it. He said he was there at 9:08. We saw it was actually 9:07. We got it. I understand. It was 9:07 or 9:08. Take your pick. It doesn't matter either way. What exactly do you want me to rewatch? What do you think I'm missing that would change the result? Untrue? What is untrue? What did I say that's untrue? Tell me a thing I said that was untrue. Kevin's right. If he had shown up before 9, it would not be harmless error. Then it would have mattered. Right. If he had shown up before 9, it would have mattered. Assuming he was supposed to be there at 9, if he shows up before 9, he's not in violation of the order. So then it would matter because the judge issued an improper warrant and he's being held illegally. Right. That would not be a harmless error. If he had shown up before 9, it would not be harmless error. But he didn't show up till after 9, so it's harmless error. Again, how do we know he was not waiting outside till 9? I don't care. I don't care if he was immediately outside the door. Doesn't matter. Doesn't matter. He has to be in the courtroom by 9. That's the law. If the courtroom appears to be a bit crowded, he should open the door and say, I have to get through. Got an appearance here. Got to get through. And so I'm going to wait. I'm just going to wait outside the doors until it thins out a little bit. No. So sure, let's go with the premise he's standing outside the doors at 8:55. Let's go with that. Do I care? No. His attorneys failed him? How? How does attorneys fail him? What could his attorneys possibly have done that would have made any difference? Please tell me a thing they could have done. Someone else in chat pointed out earlier, they don't issue continuances just because you're late. That's not really a basis to issue a continuance. I guess the judge could, but no. So I don't know what the attorney could have possibly done that would make any difference. He didn't miss court before his lawyer did. No, he had counsel there. He in fact said that. He said, yeah, before this guy wasn't here, but this woman was. And he says that she was on his case. She's one of the lawyers on his case. He knows that. He said that on the tape. It's like, yeah, my principal lawyer wasn't there before, but she was there, and she is a lawyer on my case. So he knows, in fact, that she represents him. So, okay, we're there. Yeah, lawyers cannot stop time or tell people to report people in the courtroom. Yep. Yeah. You could request to move your case down the dock. Again, you could, but again, you wouldn't necessarily, there's no cause. There's no cause. So, yeah, I guess you could have asked, but, the judge would in all likelihood say no. Let's put it differently. The judge would be within their rights to say no. Right? So when you're looking for an error, you're looking for something that, had it changed, it would have changed the analysis. And if the judge can do a thing, they're allowed to do a thing. Okay? If they can do it, it's not abuse of discretion. Right? That'd be the other end of the equation. It would be abuse of discretion. Right? So you're saying, okay, the attorneys could have moved for a continuance. They could have moved for it to be down the docket. Yeah, they could have done those things. Would it be an abuse of discretion for the judge to say no? No, it wouldn't. it wouldn't be an abuse of discretion. The judge could do it, but it wouldn't be an abuse of discretion. So it still doesn't matter because the judge could have said no, and that would be within her rights. So, the only way it makes any difference is if he shows up before 9, because then that would be a situation that she can't do something and she's doing it anyway. So she would be in the wrong, right? If it's before 9 and she issues the order at 8:45 and she can't, and it's before 9 and he shows up and says, you're under arrest for failure to appear, that would be a thing the judge can't do. That is not within her power. What the judge can do is say, the attorney says, I want to continue the case. I want to move the case down the docket. No. I want to issue that warrant right now. So it's not abuse of discretion. It's not a clear error. It doesn't matter. Why'd she call him back in to set the time? I don't know. Doesn't matter. I don't know. Doesn't matter because, again, if everything had happened exactly the way it should have, it still wouldn't matter anyway. Why'd she call him? I don't know. What do you want her to do instead? Notice him at 9:07 and issue the ruling then? How does that make any difference? If the judge had noticed him at 9:07, which was the first opportunity for her to notice him, and noticed him and said, I recognize you. You're under arrest. So the fact that she called him in and said, I want to establish the time, what do I care? Doesn't matter anyway. If the judge had done everything right, it wouldn't have changed. He has an order to appear at 9. It's after 9. I'm not sure there's anything else that would change this analysis. Azroth says, so if he was there at 8:45 and this still happened, the judge by rule can still declare him late. No, then it would be a harmful error, Azeroth. That would be a harmful error. That would be abuse of discretion, harmful error. Yeah. If he was there before 9, it would be a harmful error. She can't issue that a warrant at 8:45. She can't. So if he's there before 9, it would be wrong. It would be illegal. It would be false imprisonment to arrest him. Yeah. If he's there before 9, that would make a difference. She can't issue that order at 8:45. She damn sure can at 9, though. So, someone may be incompetent. It just doesn't matter. It doesn't matter. It doesn't matter. Nothing matters because, if she had, you guys, I'm not sure if you guys are fully getting this or not, but I'll keep explaining it, even though it's a bit redundant. I'll keep explaining it as long as people in the chat, don't seem to understand this because I'm a good teacher and I'll continue to explain it. If she had done everything right, if she had been fully competent, if she had been fully aware of the time, if his lawyer did everything right, if the prosecutor did everything right, if the judge did everything right, it just doesn't matter. None of it matters. He had an order to appear at 9. He's not there till 9:07. She can issue the order at 9. If she had done everything completely right, he still wouldn't have been there at 9. She still would have issued the order. I think we can agree on that. She issued 8:45. Why wouldn't she issue it at 9? I mean, why? If she's going to issue it at 8:45, why wouldn't she issue it at 9? So, yeah, I don't think there's something magical in that 15 minutes that somehow would have changed her decision making, right? So, if she had issued it at 9, if the defense lawyer noticed right away, if the prosecutor noticed right away, if the judge had noticed right away, said, yeah, you were here at 9:07, what do you want? Oh, the defense lawyer should have moved for a continuance, should have moved it down the docket. You don't have cause, and it wouldn't be an abuse of discretion to say no. That would be a thing the judge could do and seems very likely for her to do, particularly because he apparently has been warned explicitly before. Apparently, it seems to be on the record, apparently explicitly before at some prior hearing, he was warned explicitly, next time you're late, warrant will be issued. Right? So, would she have issued it at 9 o'clock? Kind of thinking she would issue it at 9 o'clock, kind of thinking that was what she was going to do. So we think the judge is going to commit a crime. Let's issue a warrant, wait to see what happens. Again, DSS, assuming it is a crime, which seems unlikely, but even given the premise that what the judge did was illegal, it doesn't matter as to him. It matters as to her liability. So she might have liability, potentially, although unlikely. But if she had done everything properly, it still wouldn't matter as to him. So whether she committed a crime by issuing the warrant at 8:45 doesn't matter as to him, because if she hadn't done that, if she had waited till 9, it wouldn't have been illegal, right? So nothing changes in the analysis. It would have come out exactly the same way either way. What if he's arrested while going through security at 8:55? That would be a wonderful affirmative defense. That would be great. Yeah, that'd be very helpful. I was making every possible effort to be here, but I was arrested and I couldn't appear. That'd be an outstanding defense. That'd be great. So, yeah.
A new judge from that.
Guys, this is just the tip of the iceberg. There's so much more we have yet to talk about. I want to give you all as much information in part 1 as possible without overloading you guys with too much info. I think this investigation is proof at how easy it is to conspire against the common citizen in the court of law. How many times has this happened before? Guys, please, let's hold these people accountable. Share this video, voice your concerns. This needs to be exposed.
How do you know his case would have been called at 9? Well, if you want that information, you could determine that by just looking at the docket. The docket would list the cases. So, but, yeah. Kurt has the patience of a saint. I try, man. I try. But thank you for the $5,
Stay tuned for part 2. This has been an ASD Docs investigation.
Okay, your ASD Docs investigation sucks.
Touch on the fact that Heather Chestnut is now the Attorney General's office new civil rights attorney, and how
She's a civil rights attorney?
yes, for the Attorney General's office.
You can't make this shit up.
I'm telling you, man, this is...
You can't make this shit up. This is crazy.
That's as soon as she left the, what is it called? I guess she got a lot of heat from co-workers, or at least that's what my other attorney told me. And so she left the Salt Lake Legal Defender Association and she moved to the Attorney General's office as their new civil rights attorney.
Okay.
And that is why I believe the AG's office refused to investigate, refused to even acknowledge my complaint.
There's nothing to investigate. There's nothing to investigate. Not from my perspective. Not from my perspective. Yeah, I mean, I'm sorry to ASD Docs over here. Maybe there's a different lawyer out there. I'll give you a different opinion. If so, I'd like to hear it. But, from my legal position, and looking at the law, which is always a good place to start, right? If he had an order to appear at 9, and he wasn't there until 9:08 or 9:07, well, kind of end of analysis on that one. If he had shown up before 9, if he had been detained, something, okay, that'd be great. But none of that happened. So, and yeah, I made a complaint to the Attorney General's office. There's nothing to investigate here. No. The judge recused themselves makes total sense. Total sense. I screwed up. Not that it matters to him, but it gives the appearance of something, so I'll recuse. Good on the judge. Good call. His other defense attorney decided to leave the office for whatever reason. Maybe she did get heat. But I'm not sure what she was supposed to do, but maybe they wanted her to do something else. So maybe she did get some heat. But, I'm not sure what it would matter either way. Maybe she's very well qualified to be the assistant Attorney General for Civil Rights. I don't know. I mean, she is a public defender, so, that would be prudent. So I'm sorry to disagree with the, creepy Halloween-esque music and the somber mood and the editing and all the rest of it. But, I'm sorry unless you can point to something specific in Utah law, in which case I'm happy to correct myself, but applying general legal principles. He was specifically warned in the past, apparently, that if he didn't arrive on time, he'd be arrested for failure to appear. He didn't arrive on time. He was arrested for failure to appear. Does it matter if the warrant was issued at 8:45 or 9 o'clock? Not really. Not in this case. No. If he had been there at 8:59, it would matter. If he had been there at 8:59, it would matter. But he wasn't there till 9:07 by his own admission. So, as the appellate judge, if you come to me as this Court of Appeals and say false arrest, sorry, no, disagree. I disagree. That's the law, right? I'm not necessarily saying it's what I want to be true, right? I'm just telling you in my legal opinion, given my understandings of the law, giving my understandings of all the situation, this is the legally correct result. As always, I'm not here necessarily to tell you what you want to hear, because I'm a good on civil law, and I give you the best opinion I can, regardless. That's why you guys come to me, for the best legal opinion, because I'll give it to you straight. And some of you might be upset I'm giving it to you straight because you want to say that the prosecutor is corrupt, the defense attorney is corrupt, the judge is corrupt, they're involved in a conspiracy. Like, I'm not really seeing that on the tape. Not sure the defense attorney says, well, maybe we'll issue a warrant and arrest him. I'm not sure that's necessarily saying what he wants to happen, or she wants to happen in this case. I'm not sure that the clerk of court, chuckling as he's being led out of the courtroom necessarily implies anything. So sorry to disagree with ASD docs over here, but I'm not seeing corruption. So no, sorry. Kuma resigned? Did he really? I've never thought that would happen. I thought for sure he would drag that out. Apparently, the New York governor resigned. I did not see that one coming. I thought he would drag that out forever. Yeah. No names, just opinion says you're good on civil law. I try to be. Yeah, people think they're far more important to the court than they are. Yeah, this is definitely just another day for the court. I guarantee you that. I think it's extraordinarily unlikely the prosecutors and defense attorneys and judge decide to target you. And for some particular reason, not really seeing that one right now. Not seeing that, Eleanor says, "Oh, Uncivil, you're lovable like Oscar the Grouch." I'm not sure how to take that, but thank you. Then tell me why they started the case 15 minutes early. I can't tell you why they started the case 15 minutes early. It just doesn't matter for many reasons, as I've explained. I don't know. Maybe the court made a mistake. Let's go with the court made a mistake. How about that? How about we assume that people are human and the court made a mistake? How about that? I don't know. I don't know why the court called it 8:45. Just doesn't matter. It doesn't matter. If the court had called it at 9, everything would have still been the same. If his lawyer had made the objections, everything would have turned out the same. If his lawyer had made an argument when he's ready to be arrested, everything would have been the same. There's nothing here that would have changed the analysis. Because 9 o'clock, 9:07. So all you have to conclude what we know for sure, apparently, although it wasn't established in this video, but we'll say it's for sure. What we know for sure is he was supposed to arrive at 9 o'clock. What we know for sure is he wasn't there till 9:07. So here is the only sort of inference you have to make. Okay? Here's the only inference you have to make. We know he's supposed to be there at 9. We know he was there at 9:07. Here's the only inference you have to make. The only inference you have to make is the judge would have issued the order at 9 o'clock. And since she ordered it at 8:45, why wouldn't she issue it at 9? Especially with a prior warning apparently on the books. I mean, I don't think anything was going to change magically in that 15 minutes, that somehow, 15 minutes later, she would have come to a different decision. It's 9 o'clock, so I'm going to, be a little bit more gracious today. I'm not really sure her decision-making is going to change a lot in that 15 minutes. So the only inference or conclusion you have to reach, the only sort of supposition you have to reach, is the judge would have, in fact, issued the order at 9. And, yeah. So, yeah. 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 Go FUYS says, love you. I'm having dreams about you. Okay. Excellent. Yeah. No. Yeah. And also A. Hedinger is quite correct. A. Hedinger is also quite correct. You don't need to be warned. The summons is the warning. So even if he hadn't been warned in the past, she still could have done it. But it just substantially increases the likelihood that she would have done it in this situation, right? So she could have done it anyway. But the fact there was apparently a specific warning on record that she knew about, apparently, and the fact that he's appeared late before is something that she knows about, apparently, and that seems to be true. He was at least absent once or late once. I mean, he does have a bit of a record for being late, which is true. So, yeah, given that, would you expect her to issue the order at 9? I mean, I would. It was not a fair and impartial hearing. It was definitely fair. It was fair in every possible legal sense of the word. There is nothing here legally unfair. If everything had happened the way it should have, it would have come out the same. Yeah. As a court of appeals judge, I'm not gonna, if I'm not gonna look at this any differently. Garvin says everyone chat is grouchy because they can't deal with, but he was still late at the end of every one of their arguments. Yeah, apparently. It's like, how about this fact? How about this fact? How about this fact? I'm like, okay, here's really the only facts that matter, really, at the end of the game. Here's really the only facts that matter at the end. He was supposed to be there at 9. He was, in fact, there at 9:07. Those are really the only facts that matter. And then you just have to reach the conclusion that the judge would have issued it at 9. And given that she issued it at 8:45, I think she's going to order it at 9. So, the only facts that are really relevant in this equation is he was supposed to be there at 9. He was, in fact, there at 9:07. He's late. He is, in fact, in reality, late. I mean, that's just an objective reality. 9:07 is, in fact, after 9 o'clock. So, the lawyer can't be sued for malpractice. It won't work. It won't work. You can't point to a mistake the lawyer made that would have changed anything. Yeah, malpractice only applies if the lawyer did something. Again, it's kind of like an error. Did the lawyer make an error that would have made a difference if the lawyer had done everything right? And the answer here is no. So there's no malpractice. There's no malpractice. If the lawyer had done everything right, it still wouldn't have mattered. So, yeah. So that's not going to work either. Zen says, so we should lock people up for walking into a room 7 minutes late. Well, when you have a summons to appear before a court, it's not a recommendation. And when the court says at 9, they actually mean at 9. They are not playing around. They are not kidding. You are commanded to appear at 9 o'clock. Yeah, that's a lawful order. That's a lawful order. You know, you're commanded to appear at 9 o'clock. That's a lawful order. So yeah, in this situation, yeah, we can arrest someone for being 7 minutes late, particularly when they have a history of it. But even if they didn't, we could do it either way. So yeah, in this situation, yes, that's fine. His own lawyer did him dirty, not clear sure how. Recusal is not a sign of guilt. That's absolutely correct. Save Mars. It's not a sign of guilt. The justice must be done and seen to be done. Judges must be impartial and seen to be impartial. The judge made a mistake. She's seen the video. She realized she made a mistake. So she recuses herself out of an abundance of caution. I have no problem with this. I applaud the judge. Sounds great to me. Is it just trolls venting? I don't know. I don't know if it's just trolls venting. I'm going to assume the questions are in earnest, and I'll keep explaining it. Incidentally, one of the reasons I say things multiple times on videos in general, specifically on like legal points that I think are particularly relevant or particularly matter. One of the comments I got in response to the critical K, response, one of the people said, "Oh, this is too repetitive. You repeat yourself too often, particularly on the malice thing." And I'm thinking to myself, one of the reasons I repeat it a couple times is because I think it's important. Repetition is the mother of learning, and I want to increase the probability that you'll hear it. So if I just say it once, it's like, law school professors can also be repetitive, as you might appreciate. They will say the same thing more than once for this reason, So yeah, I it's like, I always enjoy this comment on my comments. It's like, oh, you're too repetitive. You're saying the same thing too many times. I'm like, I say it multiple times to make sure that I have the best probability that everyone will get it and understand it when I think it's important. So yeah. Bear Ironhand says, we're just trying to keep this going all day for fun. We want to hang out with Kurt all day so we can keep the argument going. Maybe you could ask me something different. Ask me a different question. Yeah, Michael's right. If the flight leaves at 9, you got it right, Michael. Yeah, you got it exactly on the money. If the flight leaves at 9, if the train leaves at 9, sometimes the time really matters. This would be one of those occasions. Yeah. In the start, where you explained how the presenter was presenting all evidence to support their case and how you did the reverse to argue, may have helped the latecomers. Oh, well, yeah, sure, but I don't think it would have changed anything. But because I thought that this was going to be more, was going to have more, because I hadn't seen it in advance, right? So when I saw the title of "Watch Defense Attorneys Conspire Against Their Clients," right, I'm kind of assuming the worst. So the preface I gave at the beginning was twofold. First, I am an attorney, and I do want to assume the best of my profession. While there are incompetent and corrupt attorneys, there are corrupt and incompetent, insert the blank of literally anything else in this sentence. And the number of incompetent and corrupt attorneys is, I don't think, any inherently greater than any other profession, to the best of my knowledge. All the ones I've interacted with have been honorable. Personally, I've never run into a corrupt or incompetent attorney. It's never happened to me. So, I assume the best of my profession. And that's one of the reasons why I interpret the comment from the defense attorney. I was like, well, maybe we'll call it an issue of the arrest warrant. Maybe that's one of the reasons I interpret that comment that way. Because I'm assuming, well, maybe they might not be talking for themselves. They might just be talking about what they expect the prosecutor to do, or what the court to do, and so they're just kind of chuckling about it. I'm not really seeing the conspiracy there. So that was one. The other thing I said is I know that this guy is not trying to be unbiased. He is obviously trying to present a case for a proposition. His title is Watch Defense Attorneys Conspire Against Their Client. Not really hogging the ball on that one. We're not trying to be neutral. We're trying to make a case. So I say, well, okay, if he's trying to make a case, I'm going to assume that all things that he presents are the best things that he could find to support his proposition. And I'm going to assume anything that doesn't support his proposition, he's going to exclude. That's a reasonable assumption, right? He's trying to advocate for a case. So like an attorney would, for that matter, he's going to emphasize the bad and try to dismiss he'll emphasize the good, sorry. Like a lawyer, he'll try to emphasize the good and diminish the bad. That's what attorneys do. They emphasize the good, diminish the bad. Right? So I'm like, okay, that's probably what he's going to do because he's advocating. But then, we didn't really get evidence of the corruption from the minor laugh and whatever. And we got the critical facts of he's supposed to be there at 9 and he didn't come there until 9:07. I'm like, oh, okay. So, David Perry says this is a crazy story. Yeah. The judge issued a warrant before the crime was committed. That's technically correct. Yes, we get it. We understand this. We understand. We get it. I understand. I completely get it. I'm 100% on board. The judge issued the warrant before the crime occurred. Right. I get it. The judge made a mistake. The judge committed an error. Correct. I completely understand this. I get it. If the judge hadn't done that and issued it at 9, harmless error. I completely 100% understand this facts. Can I answer your super chat? Sure. I just didn't see it because, paying attention to things, but no problem. Let me see if I can find it. I didn't see a question. Hold on. Michael Palmer, I don't see a super chat from you. Let me see if I can scroll up and find it. Oh, there it is earlier. Sorry about that. Michael Palmer gave me $10. Uncivil Law. What about the guy in Washington? They put in the same cell as a kid's sister's rapist and killed him and got 25 years. Weren't they negligent in putting them in the same cell? Yes, probably. That might be a violation of depraved indifference, which is what you're looking for in that kind of situation. So, yeah, you could show, or some, what is it? Is it actually depraved indifference, or is it different? It's something like that. It might not be depraved indifference, but it's the same idea. But yeah, if you can show that the jailers knew that, right, and they completely disregarded it, yeah, then you could show a violation under the 8th Amendment, and that would be a 1983 violation. So you could sue for that, presumably. You might have to show the case, a well-established case, but I'm sure you can find one somewhere on that point. But yeah, that might very well be a 8th Amendment violation, and it might very well be a 1983 cause of action. Sounds plausible. Of course, the fact that they did that in no way excuses the murderer, right? People are responsible for their own conduct both ways. So the jailers are responsible for their conduct. The murderer is responsible for his conduct. So he should get 25 years. He murdered somebody. He wasn't supposed to do that. So, yeah. And if you can show the jailers knew that and were willfully disregarding, or whatever the correct phraseology is on that, then yeah, you can get an Eighth Amendment violation, and therefore you have a cause of action under 42 U.S.C. 1983. Sounds plausible. Sounds workable. Thank you for the $10. Sorry I missed it earlier. Careless indifference, that sounds right. It's something like that. It's one of those things. Careless indifference, something like that, yeah. Yeah, that sounds right. Let's bring this case off if Blackleaf is ever late to a stream. Well, like one of the nice things about being the judge is the judge doesn't have to obey their own orders. So if the judge is late, it's fine. The judge can't be in contempt of themselves. So we're fine. Yeah, you should definitely be early. To be quite fair, he really should have been there at 8:45. I mean, he wasn't legally required to be there at 9, but my advice is, let me put it this way. My advice to you as a lawyer is you should definitely be there 15 minutes early. You might want to go for a half hour early. Just saying. I know you can technically walk in the door at 9, but my advice to you, 15 to 30 minutes early, kind of like boarding an airplane, right? You should be at the airport an hour early, right? So in the same way they will say you should be in the airport an hour early, I'm going to say to you, you really should be there 15 to 30 minutes early. So, just saying. Any interest in covering Asturo versus Capito? I'll take a look at it. I'll put it on my list of things to do. Thank you very much for the super chat. That's probably not an occasion where you want to stroll in the door at 9 on the dot. Just saying. Early is on time is late. Just saying. Where is my thing for paid stories? There it is. Yeah. So, yeah. Deliberate indifference is a different standard. William, I know that. I understand that willful indifference deliberate indifference is a different standard. I get it. I understand they're not precisely the same thing. I understand. They're kind of in the same milieu. So, they are different than, deliberate, what did you say? Deliberate indifference. Yeah, it's different, but, couldn't remember the exact phrase. I got something that was in the ballpark. So, cut me some slack. I'm going to end now. If you've enjoyed the stream or not, give it a like or give it a dislike. Either way would be fine. You're allowed to disagree with me, and apparently you do, because you don't like the answer I give. But, that's my answer, for better or worse. So if there's another lawyer out there who wants to disagree with me, that's fine too. But, that's my answer. So, yeah. Please remember to subscribe, and if you're not a member already, you can join by hitting the join button or hit the link that is given to you by Discord. So until later, my friends, hope all's well. Cheers and goodbye.